Hi everyone, my name is Shazia Khan, and today's session we'll be doing is the unit is public law, and we will be looking at learning outcome 3 today, which is to understand the meaning and consequences of the rule of law and parliamentary sovereignty. Firstly, what I'm going to do is I'm going to go through what we did in learning outcome 2, just a summary of what we did. So we looked at what is the legislature, executive and judiciary. We looked at the judicial appointment in regards to how someone is appointed in judicial office in courts. We looked at the principle of separation of powers with reference to the executive, judiciary and the legislature. We looked at the roles of the legislature, the executive and the judiciary, and the overview of the UK government. We looked at the issue in regards to separation of powers, the history behind it, with the issue of when Montagu introduced the issue of separation of powers, and the two houses of Parliament we looked at, which was the House of Commons and the House of Lords in regards to the legislature. We also looked at identifying the different stages in English lawmaking, such as an introduction, the first reading, second reading, committee stage, report stage, and the third reading, and then royal assent. And we looked at the procedure in regards to that. We looked at the role of the executive in regards to the separation of powers. We also looked at the role of the judiciary in regards to separation of powers. And we looked at, as I mentioned earlier, the Montesquieu's rationale for maintaining the distinction between the legislature, executive and judiciary. We looked at the judiciary and the rule of law in the UK. We also looked at the importance of the Lord Chancellor's role under the Constitutional Reform Act and how it brought about key changes in regards to that. We looked at the significance of the separation of powers with regards to how their power is separated and the issue of checks and balances. We looked at how the institutions work together. So, for example, the executive and the legislature and judiciary. We also looked at how the executive and judiciary work together, and also the extent to which the UK's constitution adheres to the separation of powers. So, because we don't have an absolute doctrine of separation of powers in the UK constitution, executive and courts each have their own parameters, and each exercise their own powers accordingly. We looked at the UK law in regards to the Parliament Act 1911 and 1949 legislation, importance of that. We looked at the head of the judiciary under the Constitutional Reform Act 2005, and we looked at the Human Rights Act 1998. We also looked at the importance of the 1688 Settlement Act in regards to the House of Lords. And we also looked at examples in regards to the Constitutional Reform Act and the modifications, and what was brought in, the key changes and things. We also identified the importance of separation of powers in the UK and whether there was a need for the separation of powers, and we looked at the issue in regards to checks and balance and the importance of checks and balance when it comes to issues such as abuse of power from any of the organs, the legislative, executive or the judiciary. So that identifies if there's any abuse of power, that the system of checks and balances needs to be put in place. Now we're going to look at learning outcome 3, which is to understand the meaning and consequences of the rule of law and parliamentary sovereignty. So a recap, what is Dicey's rule of law? The rule of law, according to Dicey, means that no man is punishable or can be lawfully made to suffer in body or goods except for the distinct breach of law. And no man is above the law. The term rule of law thus means that the parameter of law over government. So 3 principles were proposed by A.V. Dicey. So key terminology, what do we mean by the rule of law? The rule of law definition is that the principle that all people and institutions subject to and accountable to the law. Rule of law is the mechanism, process, institution, practice, or norm that supports the equality of all citizens before the law, secures a non-arbitrary form of law, and more generally prevents the arbitrary use of power. What are the three principles of rule of law? It requires as well measures to ensure adherence to the principles of supremacy of law, equality before the law, accountability to the law, fairness in the application of law, separation of powers, participation in decision-making, legal certainty, and avoidance of arbitrariness and procedural legal transparency. The rule of law, as we've identified, is a fundamental principle underpinning the UK Constitution. Its the core principles include limits on state power, protection from fundamental rights, and judicial independence, as I explained earlier. The rule of law is durable system of laws, institution, norms, and community, as we've just explained. The British people focus on respecting the rules of the game, and their commitment to fair play ensures an appropriate balance of political and legal authority. Parliament makes the law, and the judiciary sees to it that it's applied equally to all. So it's mainly to do with equality and fairness in regards to the rule of law in the UK. Now we're going to go on to looking at parliamentary sovereignty in the UK. So what is meant by parliamentary sovereignty? So parliamentary sovereignty, also known as parliamentary supremacy or legislative supremacy, is a concept in the constitutional law of some parliamentary democracies. It holds that the legislative body has absolute sovereignty and is supreme over all other government institutions, including executive or judicial bodies. Parliamentary sovereignty is a principle of the UK Constitution. It makes Parliament the supreme legal authority in the UK, which can create or end any law. The UK Constitution, being an unwritten one, relies on parliamentary sovereignty and its rule of law to retain its authority in governing its four counterparts, namely England, Wales, Scotland, and Northern Ireland. What is the difference between constitutional supremacy and parliamentary sovereignty? The term parliamentary sovereignty means that Parliament is supreme over the Constitution. The term constitutional supremacy means that the Constitution is supreme over the Parliament, and that Parliament can exercise its functions being only within the bounds of the UK Constitution. So 3.1, illustrate the impact of Human Rights Act on the rule of law. So the Human Rights Act 1998 made the Parliament act in a way which was incompatible, made the court be under a duty to interpret legislation in a way that is compatible with the Convention, and the courts also show how the European Convention rights against discrimination. The European Convention on Human Rights reflects these basic principles. What effect has the Human Rights Act 1998 had on UK law? The Human Rights Act 1998 sets out the fundamental rights, freedoms that everyone in the UK is entitled to. So, you could have the right to freedom of speech, you could have the right to freedom of religion. So some examples for you. And it incorporates the rights into set out in the European Convention on Human Rights, which is the ECHR, into British law. The Human Rights Act came into force in the UK in 2000. The human rights were formed for the protection of fundamental civil and political liberties in the UK. They committed to the rule of law. The European Convention on Human Rights was drawn by the European Council, which was established after the Second World War in 1953. It has now over 40,000 signatories. including the UK. In the United Kingdom, and the Human Rights Act 1998 came into force in 2000. The scope of the Human Rights Act in the UK was to give further legal effect to the fundamental rights and freedoms contained in the European Convention on Human Rights. These rights don't have to do with only with matters of life and death. We have the right to express our own opinion, trust our beliefs, marry and start a family, and any other similar rights. So what are the rights under the HRA? Some of the rights are the right to life, right to freedom from slavery and forced labour, the right to liberty, freedom of expression, the right to an education, and the right to participate in free elections. There are 16 basic rights within the Human Rights Act, all taken from the European Convention on Human Rights. They do not only affect matters of life and death, like freedom from torture and killing. They also affect people's rights in everyday life. They can say and do their beliefs, the rights to a fair trial, and many other similar basic entitlements. The impact of the Human Rights Act 1998 in the UK was critical. There were areas in society that improved from the Act, but also areas that got worse. One of these areas that got worse is voting of prisoners. How does the Human Rights Act affect me? Public authorities have an obligation to act in accordance with the Convention rights, and therefore public officials must understand human rights and take them into account in their day-to-day work. This is the case whether officials are delivering a service directly to the public or devising new policies or procedures. Understanding human rights can help in making the right decisions. When it comes to a decision-making, the rights of one person often have to be balanced against the rights of others, against the needs of the broader community. But if you have to restrict somebody's rights, you must make sure that you are not using a sledgehammer to crack a nut. Any restriction must be no greater than is needed to achieve the objective. This is called proportionality. An example of its impact is Article 4, which is the prohibition of slavery and forced labour. Everyone has the absolute right not to be treated as a slave or to be required to perform forced or compulsory labour except for certain limited types of obligations specified in the article. For example, work in prison. What does the right mean? Everyone has the absolute right not to be held in slavery or servitude or to be required to perform forced or compulsory labour or compulsory labour, any work that forms part of a normal civic obligation, work during legitimate detention or conditional release from detention, i.e. prison work or community service, compulsory military service or civilian service as a conscious objector or community service in a public emergency. Keywords and meanings. So when we look at Article 4, keywords and meanings, slavery and servitude are closely connected, but slavery involves being owned by another person like a possession, while servitude usually involves a requirement to live on another person's property and no possibility of changing the situation. Forced or compulsory labour arises when a person is made to work or perform service against their will, and where the requirement to do the work is unjust or oppressive, or the work itself involves avoidable hardship. It can cover all kinds of work and services. Is Article 4 relevant to my work? Article 4 will be relevant particularly if you suspect that someone is being forced to work without suitable recompense and under unjust conditions, also have powers to make people work in an emergency, and have powers to regulate employees in relation to things like working conditions and health and safety. The Human Rights Act gives the legal protection of human rights, such as the right to a fair trial and, as we mentioned, the right to life. As we mentioned, the Human Rights Act was passed in 2000, and it's there to defend the UK's courts, rights and your rights as a public organisation. The Human Rights Act may be used by every person resident in the UK, regardless of whether or not they are British or foreign citizens. The Human Rights Acts contained within this law are based on, as we mentioned earlier, the European Convention on Human Rights. So you've got the right to life, as we mentioned, protection against slavery and forced labour, which we mentioned earlier, the right to liberty and freedom, the right to protection from property, the right to education. So these are some of the rights contained in the European Convention on Human Rights. 3.2. Explain the meaning of royal prerogative. The royal prerogative is a body of customary authority, privilege and immunity recognised in common law and sometimes in civil law. In civil jurisdictions possessing a monarchy as belonging to the sovereign and which have become widely vested in their government. The royal prerogative has been defined by some sources as the special rights, powers and immunities to which the Crown alone is entitled under common law. The scope of these powers and who the Crown has changed over time as the United Kingdom legal framework has changed from an absolute monarchy to a constitutional monarchy. In modern times, the powers and rights allocated within the royal prerogative not only apply to the Crown or monarch, but in modern day politics extend to ministers as well. This is due to the fact that many modern day prerogatives are made by representatives of the Crown rather than by the Queen directly. As the Queen has limited power, prerogatives are usually exercised by members of the executive. However, the Queen, and in this instance is the King, does have some control over the appointment of ministers, as the Queen has limited power to appoint whom she pleases to be ministers. The representatives of the Crown are usually ministers who form part of the executive. They are directly responsible to Parliament when exercising the powers of the royal prerogative. Royal prerogatives can be categorised into quite a number of different areas, such as judicial, for example. It is under the prerogative that the Crown grants special leave to appeal from the colonial courts to the Judicial Committee of the Privy Council. There are numerous other areas where the prerogative powers are used, and scope of these ranges from the signing of the treaties, which is usually done by the minister on behalf of the Queen, to the opening of Parliament. That is one of the few prerogatives the Queen still exercises herself. There is no clear definition as to the extent to which these powers exist and whether or not some of these prerogatives are still viable today. Some have fallen out of use altogether, probably forever, such as the power to press men into the Navy. It is also a matter of concern that the majority of royal prerogatives are no longer in the hands of the monarch and used by the executive arm of the government. The royal prerogative is a body, as we mentioned, of customary authority, privilege and immunity. One of the earliest reported cases that openly challenged the royal prerogative is the case of Imposition 1606. In this case, the defendant refused to pay duty on imported good imposed by the King by royal prerogative. It was held that the King couldn't do this as he was not raising taxes, but was doing this to regulate trade. This was followed by the Parliament legislating against levying taxes without their consent in the Petition of Rights 1628. This was one of the first struggles between the monarchy and the Parliament for supremacy of law under the format of the royal prerogative. However, academics have criticised the Petition of Rights 1628 as it did not in terms deal with what we now call indirect taxes, where only a little time before the judges have pronounced in Bates' case that the King did have the rights to impose taxes on imports, so it left the matter unclear. The scope of the royal prerogative and its powers has been subject to an ongoing battle between the monarch and Parliament for many years. up to the present day. The first instance where the power of the monarch was curtailed by legislature can be traced back as far as the prohibitions del Roi. In this case, it was held that the king could sit in the King's Bench, but would not be allowed to pass judgment on any matters that which concerned the administration of justice. The Bill of Rights 1688 was the next major step that curtailed the royal prerogative, as the previous monarch James II had aggressively used the royal prerogative to amend laws and to levy taxes. Under the Bill of Rights 1688, it is written that levying money for or to use the use of the crown by pretence of prerogative without grant of Parliament for longer time or in other manner than the same is or shall be granted is illegal. This extract from the Bill of Rights 1688 stopped monarchs from levying taxes as and when it saw fit. This is one of the main restrictions of the royal and prerogative powers of the monarchy, which was imposed on Prince William and Mary of Orange, as it affirmed that the monarch was subject to the law. Legislation has further limited prerogative powers, even to whom the current monarch can choose as a successor to the crown, as the Act of Settlement 1700 states that the next in line to the throne shall join in communion with the Church of England as by law established. Therefore, this means that successor must be a member of the Church of England. However, there have been calls from ministers to change this limitation, as reported. On 21st of January, introduced His Royal Marriages and Succession of the Crown Prevention of Discrimination Bill. The long title describes it as a bill to make provision to remove discrimination in respect of royal marriages and succession to the crown. This shows that Parliament is contemplating legislating in this area, which will affect the powers of the royal prerogative in choosing an heir and will allow succession of those who are not members of the Church of England. It is ever more apparent than after the 19th century the formation of stable governments due to the expansion of franchise using the Reforms Act of 1832 and Reform Act of 1867. This meant that the monarch's power under the royal prerogative to choose whom they wished as the next Prime Minister was also curtailed. Legitimate elections and the support of the public of one party gaining a majority in the House of Commons legitimised the leader of that party, meaning that it was more likely they would gain the title of Prime Minister. The formation of stable governments also meant that the monarch was more likely to use ministers to invoke royal prerogatives and not challenge Parliament or face consequences such as further seizure of the royal prerogatives into statute. One of the main fundamental legal principles is the rule of law, and this is contradictory to the royal prerogative, as DiL states that no man is punishable or can be lawfully made to suffer in the body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts. This is one of any principles that DiL states that any rule about the rule of law that contradict with the doctrine of royal prerogative, as it is not ordinary law because it is not a statute made by Parliament. Another principle DiL puts forward is that everyone is equal before the law and subject to its laws, yet under the entitlements of the royal prerogative it has been taken that the Queen or the monarch cannot be prosecuted in the courts, as she would effectively be prosecuting herself. Since all criminal cases, it is the Crown that prosecutes breaches of law through the workings of the Crown Prosecution Service. However, it is unclear as to how far this protection of these associated with the Crown from liability extends, as the Queen's daughter Princess Anne has been prosecuted in the Dangerous Dogs Act 1991. Conventions are another way the royal prerogative is limited, and there is often a blur between constitutional convention and royal prerogative. Both of these features of the UK legal system are unwritten and has given rise to many criticisms of these areas. Conventions are hard to define, but many academics have offered their opinions as to what convention is, for example, a rule of behaviour accepted as obligatory by those concerned in the working of the Constitution. There are a few known conventions, such as the now redundant Salisbury-Addison Convention, which stated that when the House of Lords had a majority of hereditary peers, they could not reject legislation that was part of the government's manifesto. There is a wide speculation to how binding conventions are ministers, as they are not enforceable by the courts, yet the courts may decide to look at conventions in order to decide a point of law. Sometimes when a convention is broken, law is also broken, as shown in the case of Attorney General Jonathan Cape. In this case, the convention of keeping ministerial expressions during cabinet meetings secret was a convention, yet also there is a legal obligation of the confidentiality as well. This is in contrast with the earlier case of Madzima Bhutto and Ladnerberg, where the courts acknowledged that convention, but it was in conflict with parliamentary supremacy, so the convention went to abeyance. It is apparent that both conventions and the royal prerogative are features within the UK legal framework that select committees have called for codification, yet these calls have been rebutted. The defence for keeping the royal prerogatives uncodified is so that it allows greater flexibility in times of emergency, and the impact on the application of the royal prerogative is not detrimental, as in the case of Attorney General and D. Cases, Royal Hotel Limited. In this case, it was held that the royal prerogative would go into abeyance as statute had legislated in the area the case was being decided upon. However, the principle of royal prerogative going into abeyance was not followed in Ireland. Secretary of State for the Home Department, XP, Northumbria Police Authority, as they decided that in matters where the royal prerogative is there for the benefit or protection of the individual, that it will not go into abeyance in this circumstances. It could be argued that constitutional conventions should not be put on a legislative footing, as it is impossible to predict every set of circumstances that could arise. This could lead to problems, particularly with the Monarch's Convention of assenting bills from Parliament was legislated. What would happen if an extremist government came into power? Would the Queen be able to prevent legislation being passed? In conclusion, the royal prerogative is an intrinsic and fundamental part of the UK legal framework. The powers afforded under the royal prerogative, although much weaker than originally were when the Stuart dynasty were on the throne, are now appropriate for a modern constitutional monarchy. This erosion of power has come about through acts of Parliament to try and redistribute power into the hands of the people. Now we're going to go on to 3.3, which is to assess the limits of parliamentary sovereignty. So parliamentary sovereignty may be considered to be a fundamental rule of the UK legal system. In brief, parliamentary sovereignty states that Parliament can enact any law whatsoever, and the courts may not question an act of Parliament or rule it to be invalid. Over the years, experts have argued for the limits of parliamentary sovereignty to be recognised, and that courts should not defend statutes which act democracy, the rule of law and civil liberties. This trend of arguing for limits to parliamentary sovereignty has now received judicial recognition in the case of R. and Jackson and Attorney General 2005, where Lords upholding the Hunting Act 2004, when Lord Hope said parliamentary sovereignty is an empty principle if legislation is passed, which is so absurd or so unacceptable that people at large refuse to recognise it as law. The primary issue here is protecting civil liberties and upholding the rule of law. The UK Constitution is often described as an unwritten constitution, but is best described as partly written and wholly uncodified. as Budge et al. 1998. The main source being the statutes, laws enacted by Parliament, thus giving the Parliament the absolute power to make and unmake laws in the whole of the UK. For example, in 1984, the government banned the Government Communications Headquarters GCHQ trade union based on untenable arguments, which was eventually reversed by the incoming government in 1997. Dicey 1964 considered parliamentary sovereignty as the primary constitutional principle and all else subordinate to this principle. The primary contention of Dicey's principle is that in constitutional democracy, power should not be absolute and it should be controlled. The fundamental question is, under what circumstances can courts question or modify an act of Parliament? Judicial review. Public law disputes are resolved through the mechanism of judicial review and stop the misuse of power to safeguard the interests of the people. Decisions of public authorities can be challenged in the courts by way of judicial review, a process which legislative and executive decisions are reviewed by judges to ensure that they are lawful. The purpose of judicial review is to ensure that public authorities don't go beyond the powers given to them by Parliament and that they don't abuse these powers. Public law is generally concentrated on the control of the government. Wade and Forsyth 2004 have indicated that the primary purpose of administrative law is to keep the powers of government within their legal bounds so as to protect the citizens against their abuse. This control is sometimes effected by use of the courts, and judicial review provides one of a number of legal controls on administrative actions. Decisions of the public authority can be challenged by the courts by way of judicial review. The court does not look at the technicalities of the decision, is only concerned with the lawfulness of the decision. The core defence of judicial reviews offered by Hamilton 1961. In the Federalist Papers, it is worth noting that Hamilton primarily envisaged the institution of judicial review as a useful check on the temporary mistemps of legislative majorities. The judiciary is not positioning itself against permanent majorities. It is not trying to tell legislative majorities or the people that they cannot have what they are convinced that they want. Rather, in particular moments when the people have lost their heads, the courts might step in and offer some corrections and appeal to the more sober sense of the people. Judicial review is an essential safeguard to maintain the standards of law and is also needed to protect democracy in difficult times. Primarily, the judiciary tries to correct badly drafted legislation and challenge the legislators when their action might result in injustice to the people. Lately, there have been significant incursions into parliamentary rule. There have been two chief mechanisms, one international and the other domestic. With the UK becoming a member of the European Community in 1973, many of the traditional views on parliamentary sovereignty have seen as a gradual change. The landmark decision in ATHE against Secretary of State for Transport gave the impetus to British courts the power to set aside an Act of Parliament. More recently, in the incorporation of the European Convention on Human Rights into UK domestic law by the Human Rights Act 1998, has led to greater involvement of the courts in considering the constitutionality of parliamentary statutes' compatibility with convention rights. Young 2002 argues that Section 3, subsection 1 of the Human Rights Act 1998 limits the power of the judiciary only to interpret statutes in a manner compatible with the convention rights. But in cases where it is not possible to interpret statutes in a manner compatible with the convention rights, the judiciary have been given a free rein by the Parliament. Pepper and Hart is an example of parliamentary imposed limit on the judiciary, but this does not limit the power of the judiciary, but merely replaces impossibility with incompatibility. More recently, the incorporation of the European Convention of Human Rights into UK domestic law by the Human Rights Act 1998 has led greater involvement of courts in considering constitutionality of parliamentary statute compatibility with the convention requirements. Young 2000 argued, as we mentioned earlier, that Section 3 of the HRA limits the power of the judiciary only to interpret statutes in a manner compatible with the convention rights, but in cases where it's not possible to interpret statutes in a manner compatible with the convention rights, the judiciary have been given a free rein by the Parliament. Pepper and Hart, as we mentioned earlier, is a great example of parliamentary imposed limit on judiciary. There has been consistent struggle between the executive and the judiciary, as seen in some of the recent promulgations. The Asylum and Immigration Treatment of Claimants Act 2004 looks at reducing the power of the judiciary. It replaces the previous system of immigration adjudicators and the Immigration Appeal Tribunal with a single tier system and Asylum and Immigration Tribunal. Conversely, it also removes judicial review, cutting off all appeals to the Court of Appeal and the House of Lords, except in cases that involve an error of law. This is not only a curb of the power of the judiciary, but the case of the executive using arbitrary power to overrule all civil liberties and human rights in the UK. Corresponding similarity can be seen in other legislations after 9/11 and 7/7, the form of regulation of investigatory powers, Communications Data Order 2003, Regulations of Investigatory Powers Act 2000, and Anti-Terrorism Act 2001, which denies terror suspects the right to privacy and civil liberties by giving the executive an overarching power to investigate terrorism and money laundering. The above pieces of legislation reduces the role of judiciary by denying the victims the right to appeal regarding the unfair practices which are mandated by the writ of law. Under these circumstances, judicial review becomes significant in guarding the rule of law and guarantee a free and fair trial while opposing the suppression of democratic values. The rule of law has played an important role in broadening the scope of judicial review. Series of decisions in the House of Lords in the last few years have breathed new life into the rule of law. Judicial independence is now insulated from other branches of government by the rule of law. This may be called a constitutional fundamental of our system of government. Challenging that system would now be difficult in the case of Anuj Fraji 2004 by a majority of 4.1. The House held that uncommunicated decision has no legal effect. The House observed that the arguments for the Home Secretary ignore fundamental principles of our law. Notice of a decision is required before it can have the character of the determination with legal effect, because the individual concerned must be in a position to challenge the decision in the courts if he or she wishes to do so. This is not technical rule, it is simply an application that the right to access to justice. That is a fundamental constitutional principle of our legal system. Clearly, this is a wide application of the rule of law beyond earlier categories. The constitutional impact of the decision is clear. So, conclusion: the classic account given by Dicey of the doctrine of supremacy of Parliament, pure and absolute as it was, can now be seen to be out of place in the modern United Kingdom. What is an issue in all of these concerns is the entire business of good government. Two central concerns are democracy and human rights. The fundamental question about democracy does not stop at the legislative and executive branches of government. If we are serious about democracy, then it must play a role in the judicial branch. Judicial review may act as a filter by providing a chance for the lawmaking community to express second thoughts or critical reflection concerning legislation and other governmental conduct. Ultimately, however, democracy is committed to the proposition that the electorate, after refining its judgment deliberately through its representatives and other institutional procedures, is the final arbiter of the constitutional meaning. 3D1. So to discuss the rule of law in relation to natural and positive theories of law. So what is positive theory of law? Positive law theory stems from the powers that have enacted it. This type of law is necessary as it is man-made or enacted by the state to protect the right of the individuals, the governed, to resolve civil disputes, and lastly to maintain order and safety in the society. What is natural law? Natural law is a theory in ethics and philosophy that says that human beings possess intrinsic values that govern our reasoning and behaviour. Natural law maintains that these rules of rights and wrong are inherent in people and are not created by society or judge or court judges. What are the differences between natural law and positive law? Natural law is universal. It applies to everyone. Positive law only applies to those people who are subjects or citizens of the government that creates the law. Natural law is now not made by people and has morals regardless of whether a government recognises it and makes it positive or law or not. So natural law theory, definition, ethics, and example. Legal positivism conceives law as the command of the sovereign. Law is law because of who pronounces it and not what commands. To a positivist, any moral duty to refuse to follow an unjust law that might exist in an extra-legal affair. And Queenie's put positive law into wide circulation. The 3 dimensions of law, legal reasoning. So this, if you need to refer to this on Moodle, the handout is in 3D1 on Moodle and has more details on there. First is legal theory, which it tells us which of a wide variety of rules we should choose. Secondly is legal doctrine, and this is the intermediary step between theory and practice. And these are rules that govern the conduct of individuals. And then we've got legal practice, which is the application of legal doctrine to given facts. When any of these dimensions are missing or deficient, the law cannot fulfill its function of providing a framework within which people living in society can conduct their affairs in an orderly, for example, coordinated manner. So again, this handout is on Moodle as 3D1, and you could look at that for more details. So we've finished the session now on Learning Outcome 3, and these are the references that we've used for today's session, which is Human Rights in the UK, an Introduction to the Human Rights Act 1998, direct.gov.uk, Times Online, reviewed the Oxford Dictionary for in 2009, Modern Constitution by Ween, Alder G, Constitutional Administrative Law, Bradley and Ewing, Constitutional Administrative Law, 14th edition, 300 Years on Our Tax Bills, Right Yet, David V. Williams, 1989, Parliamentary Report by Frank Cramner, 2009, and these are some of the other internet sources that we've used. Lawteacher.com in the Royal Prerogative, Law Teacher Limits on Parliamentary Sovereignty, lexclassrooms.com Theories and Legal Philosophy. The cases we've looked at in regards to this, which you can look at on Moodle for more additional information. Case of Imposition 1606, Prohibitions Del Roy 1607, Attorney General and Keysers, Royal Hotel 1920, Madsen Mabuto and Ladner Burke, 1969, which was the case to do with conventions. Attorney General and Jonathan Cape, again, another case to do with conventions, 1976. R and Secretary of State for the Department ex parte Northumbria Police Authority, 1989. Statutes we looked at were the Bill of Rights, 1688, Act of Settlement, 1700, the Representation of People Act, 1832, and the Dangerous Dogs Act, 1991. So we've looked at these sources. These additional sources are available for you on Moodle. Please go on to Moodle for additional sources. And we've finished the session today. The next session we'll be learning outcome 4, which is looking at the legislature and UK government. And thank you for your patience today, and thank you for attending today's session. Thank you.